Hello, my name is Matt Schaefer with the Council of State Governments. I'm a Deputy Program Director in CSG's National Center for Interstate Compacts, and today we're going to be talking about the Dietitian Licensure Compact. So we're going to be reviewing the compact section by section, pointing out important provisions and requirements for dietitians and dietetics regulatory bodies to know and understand. I'll point out here at the beginning that we are about to engage in a stakeholder feedback process for the compact. So the compact language right now is in draft form, and over the course of the next 6 to 8 weeks, we will be gathering input and stakeholder feedback on our first draft of the compact. We'll be organizing all of that feedback and sharing it with our project team, who will be making changes and updates to the compact as necessary. So as you watch this review session, if there's particular things that you notice that you have feedback on or you think could be more clear or worded differently or changed, we want to know about all of those things. So I'd invite you to fill out the online survey that we have linked on our website to give us that feedback. So with that, I will begin sharing my screen and we will walk through the compact section by section. Okay, so the first section in the compact is the purpose statement. And the purpose statement is important, especially for legislators to be able to identify really what is the purpose of this piece of legislation. Because in fact, the Dietitian Licensure Compact is a piece of legislation. It's a model piece of legislation that states will then go and enact in order to join the compact. So that's how your state joins the compact. They pass this piece of model legislation. So legislator looking at this right at the beginning here in the purpose statement can see what are we trying to do here with this compact. What's the goals? So you can see here some of the things that the project team listed: increasing access to care by providing for the mutual recognition of other member states' licenses, providing opportunities for interstate practice, eliminating the need for multiple licenses, reducing administrative burden, protecting public health and safety, encouraging cooperation between the member states, supporting our active duty relocating military spouses and their families, enhance the exchange of licensure information amongst the member states, support the uniformity of licensure requirements, and allow for member states to be able to take necessary action to protect public health and safety in their state. So the compact achieves all of these objectives, and these are the things that our drafting team wanted to emphasize at the very front of the document. Section 2 is the definitions. Definitions is an important section, and all of these terms you'll see them throughout the compact, and they give meaning to all of these terms that are used throughout the model legislation. So we're not going to, there's a lot of defined terms here. I'll also point out right here, anywhere you see a word that is capitalized, that is indicating that this is a defined term. So you can see here the word compact is capitalized. That means that compact is indeed a defined term here in section 2. So that can give you a note. If you see capitalized words throughout the model legislation, that there's a definition associated with that term. There's a lot of terms here. I'm just going to talk about a few of them. So our first term here is for dietetics and nutrition. And so this actually is a definition that we relied heavily on the Academy's Model Practice Act for our definition of dietetics and nutrition. Okay, three terms here that we definitely want to point out to you all. So, our first term is for license, and that means a authorization from a member state to use the title dietitian or engage in the practice of dietetics and nutrition. So that's going to be a question that is common with this compact, is who can actually use it. And so first thing we want to point out is that our term here for license, and then the term right under it, licensee, licensed dietitian, is indicating that this compact is meant to cover dietitians and not other related professions like nutrition, nutritionists, practitioners like that. So you can see the definition right below: a licensee or licensed dietitian, somebody who currently holds a license and meets all the requirements outlined in Section 4 of the compact, which we'll review shortly. Practice of dietetics and nutrition. Again, this definition is tied to the previous definition I shared for dietetics and nutrition. This one mentions also the provision of nutrition care services and medical nutrition therapy. We also mentioned here telehealth, manage and treatment of diseases or medical conditions. And then last term we want to point out here is our term for registered dietitian. And this is referring to somebody who holds the RD credential, so has met all of the education, experience, examination requirements approved by CDR, credentialed by CDR, and can use the title registered dietitian and the corresponding abbreviations RD or RDN. So that again is the type of practitioner who this compact is for. All right, just wanted to point out for you all the particular definitions that pertain to dietetics and nutrition. There's a lot of other terms there that are just kind of general complex terms that really don't change between all of the different occupational licensing compacts that are out there. But those are the terms that are unique to this particular profession. Moving on to section 3. So section 3 outlines state requirements to participate in the compact. So this is a current threshold or a bar of regulation that a state has to currently meet in order to be eligible to join the compact. So we say here at the beginning, to participate in the compact, a state must currently, number one, license and regulate the practice. Number two, require licensees pass a nationally recognized exam approved by the Compact Commission. This will be a decision that the Compact Commission makes. What satisfies this requirement as being a nationally recognized exam? Understanding there's only one exam out there for RDs that qualifies them to practice, and so that's the only exam that fits this requirement. But this allows us to be able to be flexible in the future if there are new exams in the future, or if the current requirements around credentialing and examinations change in any way. Require that states uh, require continuing education, and then having a mechanism in place for receiving and investigating complaints about licensees. So this is what a state has to have in place before they join the compact. They have to license. So if your state does not license dietetics, you're not eligible to join the compact. And I know this is a profession where not all 50 states regulate the practice of dietetics, and so your state has to require a license before you can join the compact, because this is a licensure compact. So you have to be comparing apples to apples, license to license, and nothing else. Subsection B here talks about what does the state has to do on an ongoing basis in order to maintain their membership in the compact? So they have to participate fully in the compact commission's data system. All of these licensure compacts that exist are the backbone is the data system that houses information about licensees, and states are uploading information into the data system, sharing information with one another about who's using the compact and any kind of pending ongoing investigations or any board actions taken against a licensee. So the state has to participate in that data system in order for the compact to function. They have to notify the compact commission when an adverse action is taken or there is significant investigative information available regarding a licensee. The state has to implement a procedure for considering the criminal history of applicants for a compact privilege. So this typically is an FBI fingerprint background check. So this is saying that a state has to have the FBI background check process in place for people wishing to use the compact. This is not saying that they have to do a background check on everybody, all their licensees, only those who wish to use the compact. The state has to comply with the rules of the commission. They have to require that a licensee retain a license in the licensee's home state and meet those qualifications for license renewal. So this is a very important point to emphasize here is that in order to use the compact is meant to provide a streamlined process for you to practice in multiple states without having to get a license there. But there has to be one license that you continually maintain that allows you to obtain that authorization to practice in other states. So the license that you're required to maintain is called your home state license. So that home state, if you look back at our definition section in section 2, home state is defined as your primary state of residence. So this is saying here in section 3, subsection B, part 5, that the licensee has to maintain a license in their state of residence. So let's just talk about an example to flesh this out a little bit. Let's say I'm licensed in my home state of Kentucky. I maintain my Kentucky license. I also have a Tennessee license across the border. With the compact, I no longer have to have that Tennessee license. I can get a Tennessee compact privilege instead. I don't have to maintain the Tennessee license anymore. But in order to use the compact, I must maintain my Kentucky license because that's where I live. I must maintain my home state license. So that's how we define home state is your primary state of residence. There are reasons for that, and if you have a burning curiosity as to why home state is tied to residency, reach out to us at CSG, and we'd be happy to explain a little bit more. Okay, so the rest of this section here just says the member states are allowed to assess a fee for granting the compact privilege. If you do not reside in a member state, you can continue to apply for that state's single state license. So let's say I live in a state that's not a part of the compact. I can continue to just apply for a regular license in a compact member state. But in order to use the compact, I have to live in a state that's a member of the compact. It's just saying nothing in the compact is going to affect the requirements established by a member state for issuance of a single state license. So Kentucky is still going to have their licensure process. Alabama is still going to have their licensure process. Texas is going to have theirs. The compact doesn't affect that at all. And then F is saying that a license issued by the home state is going to be recognized by all of the member states as authorizing practice under a compact privilege in each remote state in accordance with section 4. So this will make more sense when we talk about the next section. And then last point here in subsection G, just it says that At no point shall the commission have the power to define educational and professional requirements for a license to practice dietetics and nutrition. So the Compact Commission is the governing body that is made up of all the member states, and each state gets to elect one person to sit on the commission, and they administer and govern the compact in the long term. So this is just saying that at no point shall that entity, the Compact Commission, uh, at no point shall they have the power to define educational standards or professional requirements for a license. So they can't dictate, they can't say all the states have to require this exam, or all the states have to require this degree, all the states have to require this certification. The Compact Commission can't do that. So that this is just affirmatively stating that in subsection G there. All the Compact Commission does is ensure that the compact is functioning how it should, that compact privileges are being issued, and people are being authorized to practice in other member states. All right, section 4, this is probably the most important section in the compact in terms of dietitians wanting to use the compact. So this section is called compact privilege. It's how you obtain authorization to practice in remote states that are a part of the compact where you do not hold a license. So again, the whole concept here is you hold a license in your home state, your primary state of residence, that authorizes you the ability to practice in remote states that are also a part of the compact by obtaining a compact privilege. So let's use another example. Let's say I live in the state of Arizona. I have an Arizona dietetics license, and Arizona is a part of the compact. There's 25 other states in the compact. I can go and apply for a compact privilege in any of those other 25 states if I satisfy all of the requirements in this section. So this section is talking about the requirements that you have to have in order to be eligible to obtain a compact privilege as a licensee. So the previous section, section 3, was talking about what does a state have to have in place. Section 4 is talking about what does a licensee have to do? What does the dietitian have to have in place in order to be eligible to obtain a compact privilege? All right, so just to get right into it, subsection A talks about here's how you get a compact privilege. Number 1, satisfy one of the following. So there's two routes here, two routes. Option 1, hold a valid current registration that gives the applicant the right to use the term registered dietitian. So think back to section 2 again. You see the capitalized R and D here, so it's a defined term. If you think back to our term for registered dietitian, it was talking about somebody who has the RDN credential, someone who is certified by CDR, has the RDN credential. So that is option 1. You can hold the RDN credential. Option 2, complete all of the following. Complete an education program that is accredited by Ascend. So it's a master's or a doctoral degree programmatically accredited by Ascend or its successor, or an academic degree from a college or university in a foreign country equivalent to a degree described in subparagraph A, programmatically accredited by Ascend. So all this is saying is a master's degree or a doctoral degree accredited by Ascend, or the equivalent if you are foreign trained, also programmatically accredited by Ascend. Number 2, planned, documented, supervised experience in dietetics, again, programmatically accredited by Ascend, which involves at least 1,000 hours of practice experience under the supervision of a registered dietitian. So there's the education component here, and then here's the supervision component, at least 1,000 hours programmatically accredited by Ascend. And then lastly, successful completion of the registration examination for dietitians administered by CDR no more than 5 years preceding the date of the application, the licensee's application for licensure in their home state. So this is just saying that you have to have passed the CDR licensure examination no more than 5 years from your initial application for licensure in your home state. So those are the requirements in order to obtain a compact privilege on the education examination side. So you can either hold a valid RDN credential or complete all of these education supervision examination requirements. Now these mirror each other. It's essentially saying you can hold the RDN credential or you can satisfy all the requirements that lead to the RDN credential. So that's the pathway in order to obtain a compact privilege. Other requirements. Number 2, hold an unencumbered license in the home state. So this is just saying that the licensee has to have a clean license that's issued by your primary state of residence. So if there's any kind of encumbrances on it, if you are under suspension or your license is revoked or something, um, that doesn't qualify you. It has to be clean and unencumbered and issued by your primary state of residence. Number 3, no encumbrances or restriction against any license or compact privilege within the previous 2 years. So it has to be clean and it has to be clean for at least 2 years. So if your license comes under some sort of action or a board puts an encumbrance on it, you have to wait 2 years until your license, um, from the time your license is initially deemed restored to good standing. 2 years from that point. So let's say somebody takes an action against my license. I do all of the things that the board tells me to restore my license to good standing. My license is restored to good standing. I'm fully able to practice. 2 years from that point is when you are eligible to apply for compact privileges. Number 5, notify the commission when you're seeking a privilege. This just means you're going to apply for it. There's going to be an application process. You're going to pay any applicable fees, including a state fee for the compact privilege. So there's going to be a fee to the commission and then also a fee to the state. And people always ask about fees. Nothing in this language dictates what the fees are going to be. This is going to be a decision that's left up to the member states to govern for themselves how fees are handled. So the compact language itself is not going to say the fee shall be this amount. It's going to be the member states that come together and say, this is what we think the fee should be. Typically, it's less than a fee for a full license. So, for example, the PT Compact Commission sets their fee at $45. They encourage all of their member states to also set their fee at $45. So it would be $90 for every compact privilege that you want to obtain. Meet continuing education requirements established by the home state. So again, you have to keep your home state license in good standing. That allows you to be eligible for compact privileges. So this is just saying that in order to keep your home state license in good standing, you got to meet all the CEs, but you don't have to meet continuing education in remote states where you hold a compact privilege, only your home state. Number 8, meet any jurisprudence requirements established by the remote state. So if there is a requirement for a jurisprudence exam or assessment in the remote state, the practitioner has to satisfy that requirement. These are typically pretty easy, open book often, and just essentially an attestation saying that you have read the Practice Act in the remote state where you want to practice. So if I am applying for a compact privilege in the state of Ohio, Ohio requires a jurisprudence exam. I've got to pass that exam that says I've read the Practice Act in Ohio and I understand what I'm allowed to do while I'm in Ohio. And then lastly, report to the Compact Commission any adverse action taken by a non-member state within 30 days that the action is taken. So if there's a state not a part of the compact that has taken an action against a license that they issued to you, you've got to report that to the commission. Just a couple other notes here. The privilege will be valid until the expiration of the home state license. So the privilege renews in sync with your home state license. So if your home state license is on a 2-year renewal cycle, the privileges will last for 2 years and then need to be renewed. C, this is a very important point. Licensees engaging in the practice of dietetics and nutrition shall adhere to the laws and regulation of the remote state where they're practicing. So this clearly states that the laws and rules that apply to a practitioner are dictated by where they are practicing. So if they're practicing in a remote state, they have to abide by all of that remote state's laws and rules. So let's use an example again. Let's say my home state license is in Texas. I've got an Oklahoma compact privilege. I'm practicing in Oklahoma. While I'm in Oklahoma, I've got to abide by all of their laws and rules. It doesn't matter what I'm licensed to do in the state of Texas. While I'm practicing under a compact privilege in Oklahoma, I have to abide by all of Oklahoma's laws and rules. And if I violate Oklahoma's laws, the Oklahoma board can take action against my compact privilege. And D is talking about this particular point that the practice is subject to that state's regulatory authority. So if you violate the Practice Act in a remote state, that remote state board can take action against your compact privilege just as if you held a license there. So think back to my example I just gave with Texas and Oklahoma. If I'm practicing in Oklahoma under a compact privilege, Oklahoma can take action against my compact privilege if I violate their laws. E is just talking about how your privilege is restored to good standing if a state takes an action against it. And then G is also talking similar point about if a compact privilege is revoked, that the licensee loses their privileges in other remote states until the following occurs: fines, period of time, and no other encumbrances. Okay, so that is the end of section 4. Those are the requirements to obtain a compact privilege. Moving on to section 5, and I'll kind of move quickly through the remaining sections. Sections 3 and 4 are the most important ones to emphasize. So section 5, obtaining a new home state license based on a compact privilege. The purpose of this section is just to say if you are moving between two member states, that there is a expedited process for you to get a new home state license if you're moving between two compact states. So let's say I'm moving from the state of Georgia to the state of Missouri. Both states are in the compact. I move from Georgia to Missouri. My Georgia license essentially expires, and my Missouri compact privilege is converted into a Missouri license. So this is outlining the process for how that happens. The only thing that has to happen is a background check and any jurisprudence requirements by the new home state. So you're essentially exchanging your compact privilege for a license in the new state where you are moving. You can see here the process that's laid out. The former home state is going to convert that license into a compact privilege, and then vice versa. The new home state is going to convert the compact privilege into a license. Section 6 is specific for active duty military personnel or their spouses. This section just says that if there's an active duty military member who is using the compact, that they get to designate a home state and retain that home state designation throughout their active duty military service. So regardless of where they actually move, they have the same home state throughout their active duty service in the military. So if they are initially stationed in California, they designate California as their home state. They can move to any state. It doesn't matter. For purposes of the compact, they will always their home state will always be California. Section 7, adverse action. This just outlines the process for remote states to be able to take an action against a compact privilege. So again, the action taken by a licensee in a remote state can be treated as if that person held a license, and they can come under all of the same actions as if they held a license there. So they can be fined, suspended, their privilege can be revoked completely. So the remote state has the ability to take that kind of action to protect public health and safety. Establishment of the Compact Commission. So again, the Compact Commission is just the governing body that administers, governs, oversees the administration of the compact in the long term. You can see here in subsection B, Number 2, that we say that the delegate shall be the primary administrator of the licensing authority or their designee. And so what we're saying here is that it is the typically the administrative officer of the licensing board is the person who sits on the commission. That's the person who is eligible to represent their state on the commission. There is a lot of information here about how the commission functions. I'll just breeze through it very quickly because it's a lot of detail that really doesn't change a whole lot from compact to compact. It's pretty standard language across all the licensure compacts. So C establishes their powers and duties. D establishes the executive committee for the commission. F talks about meetings of the commission. Because this is technically a governmental entity, they're subject to all of the open meetings laws in all the member states. G talks about how the commission can finance itself. H talks about qualified immunity for commissioners, so they are acting as a representation of their state and they can't be sued and held personally liable for any actions that they take. And that's the end of the commission section. Section 9 talks about the data system. So again, all of the licensure compacts are housed by a data system that has information on licensees using the compact. Here are the type of information that is in the data system. So information about a practitioner's license, any adverse action against the license or privilege, anything about denial of licensure, presence of significant investigative information, or other information that may facilitate the administration of this compact. It talks about how the states are going to upload information into the data system and how information is treated. Section 10, so the commission has rulemaking powers. The compact statute itself that we're reviewing right now is just meant to be a broad framework. A lot of the nuts and bolts of the compact will be done by commission rulemaking. And so rulemaking is an important component of the commission to be able to respond to things in a flexible manner that arise around the administration of this compact. So they really flesh out a lot of the details that we leave more broadly stated in this compact language itself. So this just talks about the rulemaking process. The commission has to provide notice of any proposed rules and allow for public hearing if requested, and allow for comments. It has to be publicly posted, and talks about when a rule is adopted. Section 11, oversight, dispute resolution, and enforcement. So because this is a contractual agreement between states, there is a dispute resolution process in place for if there are members of the contract that are not holding up their end of the bargain. So this is the process for bringing a state back into compliance if they are not holding up their what they're agreeing to by signing on to this compact. So it's how the states oversee one another and resolve any potential disputes, and talks about the termination process if there can't be a resolution. Section 12 sets the effective date and then talks about how states can withdraw and collectively amend the agreement. So the most important thing to emphasize in this section is subsection A here right at the beginning. We say that the compact shall come into effect when it's enacted into law by the seventh member state. So this is the effective date. Until we hit 7 states, we're just kind of in this limbo period. States are passing the compact, but we haven't reached our threshold, and so the compact is not in effect. So we have to hit 7 states before that actually occurs. Again, talks about how states can withdraw from the compact if they chose to do so. Construction and severability, just as with any other contractual agreement, it can be collectively severed if all of the parties of the agreement chose to do so. And then last section here, 14, consistent effect and conflict with other state laws. This just says that if the compact conflicts with anything that currently exists in state law, that the compact would supersede. So in some instances, a state might have a particular requirement. The compact says something different. Where there are conflicts like that, the compact supersedes because the compact is the more current statute on the books, and so it supersedes that which went before it. So and a lot of people get worried about this language because anytime you talk about a state's laws being superseded, the alarm bells start ringing. State sovereignty issues are raised because the compact is just an alternative optional pathway to practice. It's very rare for there to be conflicts. So the compact doesn't touch the licensure process at all. It doesn't touch scope of practice at all. Those things are untouched by the compact. So it's very rare that a state would have a law on the books that conflicts with the compact. Sometimes you'll see it around rulemaking procedures or meetings, public meetings, notices, things like that. But around the licensure process and scope of practice, all that stuff is untouched by the compact. So it's very rare that there would ever be a conflict between the compact and state law there. So that is the end of the compact. It is, again, a very lengthy document, but most important sections for you as a dietitian would be sections 3 and 4. What does your state have to have in place? What do you as a licensee have to have in place in order to obtain a compact privilege? So again, I want to emphasize that this is a draft and that we are soliciting feedback on this draft. And there are aspects of this compact that can change if we get a significant amount of feedback about a particular item. So if you have thoughts about any of the requirements in Section 4 or about the compact privilege model or any of the definitions or anything that you saw throughout the presentation, we want to know all of that. So please check out the survey that we have linked on the website in order for you to give us your thoughts and feedback. So with that, I will wrap up and just again thank you all so much for your time, for paying attention. I understand this is a very technical document and this is often a new topic for people to understand. And so I really appreciate the time and attention. And if you have any questions, we'd be happy to answer them. Our contact information you can find on our website as well if you go to compacts.csg.org. So thank you all. And with that, we will wrap up for today. Thank you.